Our next question will go to Council Member Wade Laughter.
Yeah, Carl, really deep respect for you and some of the choices you've made in your life. I'm particularly struck by your description of your relationship to the plant and how you came to it as a sacrament. And I just want to note, with respect for your previous work with the Coptic Church and establishing the right to use cannabis as a religious sacrament, you personally have given up your own personal religious use of cannabis due to a belief in changing the laws. Can you kind of build a bridge between that activist who saw it as a sacrament and now has had to make a choice to pass on use for yourself? Thank you,
Absolutely,
Carl. This is a fascinating conversation, by the way. Thank you.
Yeah, that's a critical thing to my whole everything I do. Yeah. So in all of my cases, I argued that my religious use of cannabis, and not just me, all these other people like Tom Riley and all the other people that were involved in the church. Ramsey Clark was our attorney, former attorney general under Lyndon Johnson, and on the normal board of directors. And we made the argument that we were protected by the First Amendment, and the argument was no harm, no foul. Okay, where are the bodies? Sure, the children on TV smoking cannabis, where are they now? They're productive citizens working. They're just regular people. Nothing happened to them. So our argument was no harm, no foul. And so when we went to the Supreme Court, while my case was pending, when I went to the Supreme Court, all the other people had dropped off by then. I had this petition with the DEA to create an exemption like the one for peyote. All the other people had given up, lost their appeals. And I was the only one carrying this thing from a civil perspective. So all these cases were criminal cases, so I created the civil case with the DEA to apply for an exemption. So I'm not the defendant, I'm suing them. And so when that went to the US Supreme Court, they had a case called Employment Division versus Smith about a Native American in Oregon that was fired from his job for as a drug counselor for using peyote. And the argument was that was protected by the First Amendment to the US Constitution. And of course, they had a sacramental exemption in the federal regulations. So the argument was, hey, this really is religious. The federal government recognizes it. The ruling in that case was that as long as the Oregon drug law was neutral toward religion and generally applicable. So Oregon drug law did not have any exceptions for religion or unauthorized for non-prescription use of controlled substances, no exceptions. The Supreme Court said in that case, they were not going to bludgeon the state of Oregon with the First Amendment, and they weren't going to apply the First Amendment. And in all of my cases, I had made the argument that I should have equal protection because Iowa had a peyote exemption. Unlike Oregon, Iowa has always had this religious exemption for peyote, and the federal government has always had the religious exemption. So unlike Oregon, I was living in places that did have religious exceptions. And so I said the law is not neutral toward religion, it's not operationally neutral toward religion, and it is not generally applicable. And the courts all agreed with me and said, okay, we're going to apply something called strict scrutiny, the compelling interest test. And they said, your use of marijuana is not like the use of peyote because they're not the same substance. The use of peyote is limited and your use is unlimited. The way that you use it is constantly, all the time, everywhere. Marijuana is in high demand and peyote is not. And peyote is obtained legally in Texas, and the Texas peyote suppliers are licensed under Texas law and federal law. And I had no way of saying where I was going to get marijuana legally. There were no legal sources in the United States. So I said, the federal government should give me a canister with 300 cigarettes in it with a prescription to smoke 10 a month, or 10 a day, like the patients had on the compassionate use program. And they said, no, we're not going to make a religious exemption where we supply you with free marijuana. And so I lost based on that. So at that point, I knew that the Constitution doesn't get up and walk around and enforce itself. It's whatever the US Supreme Court says it is. At that point, I no longer had an argument that what I was doing was legal. It was toast. And so I stopped using marijuana because I couldn't afford to get 3 strikes and you're out. And I had no legal defense, no credible argument. So I said, I'm going to wait until the law's not generally applicable, but I'm going to use marijuana as my equal protection argument the next time I come back. Well, Iowa did that in 2017, and my lawyer just filed our reply brief in court today, and we're litigating that in Iowa District Court, and I have a petition pending with the DEA for the same thing, saying that now there's a legal source where I can get it. And the other thing is that this manufacturer in Iowa called MedFarm, they just got a DEA license for bulk manufacturing. So that means they have a federal license to grow marijuana. So I could say there's actually a place that's legal under both state and federal law where I could get the marijuana from, and they will sell it to me because they sell marijuana. I wouldn't be asking for a free handout. I would be willing to buy it. So that's why I quit using marijuana 32 years ago, and I made that sacrifice because there was no other intelligent thing to do. If I wanted to stay involved in the legal fight, I had to have a legal argument. And so to make the whole thing, and another thing is, like, the state set up this illegal program to distribute cannabis. They've got a federally criminal enterprise running this thing in Iowa, growing the marijuana, and they got a federal license now to grow bulk marijuana for the DEA, but that doesn't apply to what they're doing in Iowa. They're violating federal drug law every day. So I was able to use that and go to the board that regulates the program and say, well, I had declarations from Iowa legislators saying that we just violated federal law. We're violating federal law in the newspaper, on the TV. And I gave that to the board and said, are we? And they looked at me like, you're not supposed to ask that question. Of course we are. And so I said, if there was something we could do to fix that, should we? And they said, yeah. And I said, well, hey, there's an exemption we could get. Peyote's got one. There's no way the government could say we don't qualify. We got this well-controlled program here with no diversion, no adverse health impact. We should qualify for an exemption. That's safer than the peyote exemption, for God's sake. And they said, okay, let's do that. So then they backed out of it. They wanted the legislature to enact that into a law. And so the legislature said, we're going to apply for federal funding guarantees. Then the Department of Public Health said the only way to get federal funding guarantees is to apply for this exemption Olsen is talking about. And then they didn't do anything. So I had to sue them for mandamus to file the damn thing. So they filed for federal funding guarantees, and I filed that with the DEA saying, wait a minute. And I attached the document where they said federal exemption was the only way to get the federal funding guarantees, and said, they know they need a federal exemption, and you know you can give them one. That's what this is about. This is not about federal funding guarantees. We need an exemption from federal drug law to make the whole thing legal. And so that's what I was able to do by saying, I'm not breaking the law. Why should you? Like, didn't you ding me my whole entire life for breaking the law? And now it's just okay for everybody to break the law? When did that happen?
I got to say, Carl, I have such deep respect for your commitment to making change in the law.